Kevin Hunt with Jeff O'Brien here on the Business Forum Show, and we're talking about contract law and some of the boilerplate terms that show up on the end of your contract. And before we get into some of the detail here, explain what a boilerplate in a contract is.
Kevin, the boilerplate is those seemingly insignificant terms at the back of a contract that your lawyer puts in and that you get upset with him or her for putting them in because that's not part of the deal. And you don't necessarily understand what the whole point of it was, but they are they're time tested. They're based on just fundamental contract law, and it's a way of buttoning up and sealing up the contract that the parties have negotiated to avoid issues in the future should a dispute arise.
Well, very good. So let's talk about notices and specifically a notice clause that should be in that boilerplate.
Sure. Well, a lot of times in a contract, there's some reason why one party has to give the other party notice of some kind, written notice of some kind. In a lot of times it could be that there is a potential breach of the contract, and so the one party gives the other party notice of the alleged breach and gives them, 30, 60 days to cure the breach. Otherwise it would be actionable and give rise to other remedies. And so it's important to specify how those notices are to be given. Saying written notice, great. In an era when we have text, fax, emails, letters, regular mail, certified mail, what is considered valid written notice? And so I've got my little standard contract here, and I've got a provision in here. This is from a consulting agreement, and it says, any notice required by this agreement shall be given by delivery to company or consultant personally or by mailing thereof by a certified or registered letter addressed to the company or consultant at the address set forth above. Now, sometimes in a notice clause, you may have the addresses set forth right in the notice clause. Sometimes, in this case, the addresses are set forth at the beginning of the contract. But you see the reference personally delivered or mailing by certified or registered mail. And
something
even though
you have a receipt for.
Exactly. Even in this day and age, with all the different means of communication, electronically and otherwise, you want to have proof that that notice was given, and the surest way of ensuring that is personal service, where the process server provides an affidavit of service.
And this should be, if somebody's going to do personal service, should it always be somebody who's not an involved party in the contract?
Hire a process server. They know how to do it, and they give you an affidavit saying that it was taken care of.
Sure.
You don't have your law firm go out and do service. And then you also can do, in this case, you do certified mail. So you'd have the certified mail receipt, and you'd have, like in my office when we do service by certified mail, I have someone from my staff fills out an affidavit that service was provided. So those are kind of the ways you get that, like you said, that you get that receipt, that proof that service was made, of the delivery was effected of the notice.
So without proper notice clause here, there's all different types of ways that people can communicate and conditions in which they can communicate. What types of haywire situations can happen if you don't have a notice clause in that boilerplate in the contract?
Well, if somebody is, in case of like a breach situation where there's a cure period, if someone decides that the notice that was given wasn't effective, or so let's say that someone tried to send an email and someone's email was down, and didn't get, you can say, put a read receipt attached to it, but, you can always ignore and say, don't send the read receipt. So there's problems in that as to how do you prove, in terms of trying to calculate out what the timing is for the cure period and when it ends, how do you calculate, or how do you determine if notice was given? You've got in a lease situation, you may be required to give, let's say, a lot of times we'll say, it might be a such a fixed term, and this could be any kind of contract, fixed term, and then it automatically renews every year, unless written notice is received 90 days prior to the termination, the renewal date.
Mm-hmm.
Well, if you send it by email and the party never gets it, there may be provisions for damages for wrongful termination because they didn't receive the notice.
Mm-hmm.
So you got to specify what is it effective upon receipt? Is it effective upon sending? What's the mechanism in terms of how you provide it? All those things. Again, we're trying these goofy little clauses are designed to head off disputes if one should arise.
Mm-hmm. So we've had a conversation here about just one of them, notice clauses. There's many different clauses that will fit into the boilerplate in a contract. How advisable is it for somebody to, and I know the answer to this question, but I'll give you a chance to respond to it. How advisable is it for somebody to say, what, I'll just throw this together myself and handle this problem? No problem. It's just a insignificant contract. I'll write it up, draft it up, and I'm good to go.
It's not the best idea in the world. What I tell my clients sometimes, and I understand that clients, that business people, want to save money and they don't want to be giving it all to their attorney. So sometimes, if you've got a smart business person, I tell them, go ahead and write up your contract, but let me have it next. Before you sign it, let me see it. Mm-hmm. And sometimes it may be just a situation of changing a word here or there and popping these goofy little provisions into it and sending it back to them. Mm-hmm. That's fine. But at least have an attorney look at what you've drafted before you sign it. Even if you don't want to have them start from scratch and do it, if you're trying to save a few bucks, at least have an attorney set his eyes on it and give you some advice on it.
So, what situation do you think all these online sites are creating that are suggesting to people that they can go this alone? Do it yourself.
Well, we've just been talking about these different boilerplate provisions. All those online sites don't explain what they do. Mm-hmm. Obviously they're important. And so there's a reason they're there, and you don't want to just take a form and say, well, I don't need this, this, and this, and this, and delete them all out and realize that you've just jeopardized your enforceability of a contract. Mm-hmm.
Kevin Hunter with Jeff O'Brien here on the Business Forum Show, and if you're drafting contracts in your business, as Jeff says, you could start out on your own on this, but always get an attorney involved because your DIY might end up being SOL when you're all said and done. Again, Kevin Hunter and Jeff O'Brien here on the Business Forum Show. Thanks for listening.